Okay, and another question for you, Magistrate. As far as the swearing-ins, do you need an officer to do that, or?
No, the clerk can do that.
Okay, all right, so we'll go ahead. Let me start my thing. 1 second. I didn't hear it on my end, but Magistrate, we started the hearing, so.
Okay. All right, I'm starting. Good morning, everybody. Today is November 6, 2024. This is a code enforcement hearing for the city of North Miami. And I'm the special magistrate designated by the city to sit on these proceedings. The special magistrate is empowered by Florida law and the North Miami Code to conduct code violation hearings. The purpose of this hearing is to determine if a code violation exists at your property as observed and cited by a code enforcement officer. The city is not able to prove its case, then I will dismiss it and you may leave. These proceedings are being recorded, so all persons who are speaking should do so one at a time to ensure that all the testimony is clearly audible on the recording device. If English is not your primary language, then please inform me when I call your case, and we will provide you with a translator who will assist during the proceedings. When your case is called, the property owner, agent for the property owner, and any witness should announce themselves. When asked, please speak directly into the microphone and say aloud your name, spell it, your business or mailing address, and your relationship to the property. If you are not the property owner or an attorney at law representing the property owner, then you must present a notarized power of attorney or an affidavit in order for you to be able to provide testimony on behalf of the property owner. For new cases, you will be asked for the record if you're aware of and understand the violation that is being heard today, and if you understand what is required to resolve the violation. The city will present its case first, and then the property owner, alleged violator, will be given the opportunity to testify on their own behalf, to bring witnesses, and to present evidence and photographs, and also to cross-examine the city's witnesses. Following the case presentation, I will issue findings of fact on the case. If I find that a violation of city codes exists or existed at the property, then depending on the case type, I will set a compliance or an abatement date for the violation to be resolved. Or for repeat violations, I will impose a daily fine. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation and a daily fine amount that I may impose at a future hearing should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table or continue the case to another hearing date in the future. If you do not agree with my findings of fact or my ruling, then the property owner may appeal the administrative order on the case to the Circuit Court of Miami-Dade County. An appeal must be filed within 30 days of the date of the execution of my administrative order to be appealed. In accordance with Florida law, if a person decides to appeal any decision made by the special magistrate with respect to any matter considered at these proceedings, then the person will need a verbatim record of the proceeding, also called a transcript. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the responsibility of the appellant, and it is recommended that persons who plan to appeal their case should provide their own court reporter at this proceeding. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. Current cost assessment is $100. Once the city records an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. I think at this time, the clerk will swear in the witnesses, and then we will follow with the Pledge of Allegiance. Unless the officer has arrived. If the officer has arrived, then the officer can swear in the witnesses.
Yes.
And also,
here?
Yeah, is the officer here?
Yes, he is. So I'll transfer my headset to him. Give me a second.
Okay. And officer, please tell us who you are, and welcome.
Good morning. Let's start with the Pledge of Allegiance.
Tell us who you are, and we welcome you to the special magistrate hearing.
My name is Sergeant Emmanuel Ocean. Typically, Officer Carter is the one who does the Pledge of Allegiance, the swearing in, but she's not available this morning. I'll be filling in for her.
Okay, so the first thing we do, Madam Clerk, is we swear all the city witnesses first.
All right. We'll go ahead and do the Pledge of Allegiance, then we'll swear in the inspectors and then the translators. That's what I'm being told.
Excellent. Great.
All right. So if you guys could please put your right hand over your heart and repeat after me. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. And if the inspectors would please enable their audio and videos for the swearing in. All right. Now, if you are giving a testimony today on a case, please rise and raise your right hand.
I go there.
Do you swear or affirm that the testimony you're about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? Say it aloud. I do.
I do.
I do.
Okay. Thank you. You may be seated. Now, the translators, if you would please enable your audios and videos. Okay. So we have two translators. All right. You solemnly swear or affirm that the translations which you're about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability. Say, I do.
I do.
Thank you very much.
Okay, so are we ready to start the meeting? And if so, I would ask the clerk to state if there's any amendments, deletions, additions, any corrections to the agenda. Please let us know.
Magistrate, we do have an amendment to the agenda. That will be item number 6. This case is actually closed. And that's the only amendment to the case, so I'll go ahead moving forward with the instructions.
Okay, good.
Good morning, and thank you for participating in today's special magistrate hearing. I will review the process by which today's hearing will be conducted. Make sure your device is always muted unless you are giving testimony on a case. If you are using 2 devices to participate in today's hearing, be sure your audio is only enabled in one. When your case is called, if you are signed into Zoom, you will receive a notification giving you access to audio and video so that you may give your testimony. If you are physically at the City Hall and wish to give your testimony, you must sign in with the code clerk and await your text message indicating your case is ready to be heard. Upon receiving your message, you shall immediately come into the code compliance office to be provided with access to a computer. If you would like to speak on behalf of a case, once the case is called, you should click on the raise hand button to be acknowledged. Before giving your testimony on the case, please state your name, property address, and relation to the property. If you wish to have any inspector assist during your case, please indicate this when your case is called. Magistrate, that conducts the instructions.
Okay, are we ready to call the first case?
Yes, we are. We actually have a person in the lobby that's here, Mr. Draco. Magistrate, he is item number 9 through item number 11 on the agenda.
Hi.
Okay. And is Draco his first name or his last name?
First name.
Okay. So your last name is Romaniuk Nunez or?
Correct.
Okay. Sir?
Magistrate, before you start, I want to call the cases into the hearing. Would you like for me to call all at the same time or individually?
What do you mean?
You want me to mention all 3 cases at the same time, or you want to go by them one by one?
Let's go by one.
Okay.
We have 3 cases, right?
Yes.
Okay.
So, Mr. Draco, if you please raise your right hand. Do you solemnly swear that the testimony that you're about to give in today's proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
All right, perfect. Magistrate, item number 9 is Draco. I'm sorry. Say that.
Romaniuk Nunez.
I have
Draco.
I have the sun in my face, so I have to
Sorry.
do a little change here.
No worries. Draco Ramunic Nunez, case number CEBPR 2023-00837. The officer on this case is Gennaro Murillo.
Okay, before we called Mr. Murillo, how do you prefer that we call you? Romaniuk Nunez or Nunez or?
Romaniuk Nunez.
Okay. Sir, first of all, you're under oath. I'd like you to tell me where you live, your relationship to the property, and if you agree with the violation that has been issued for requiring you to obtain an after-the-fact permit for the new fence that you installed.
1415 Northeast 140th Street, North Miami 33161. And I'm willing to work with the city to try to fix this problem. I want to correct it.
Okay.
We hired a contractor to help us do so, and he actually ripped us off $7,000. He never did anything for the matter. So, and I'm the property owner. So.
Okay. Let me first have the inspector present the case and put on any evidence, photographs and other documents in order so that I can understand exactly what the violation is.
Okay.
Morning, Your Honor. You want me to present all cases or one?
That we're only case number 9 for an after-the-fact building permit for the new fence and gate.
Yes, Your Honor. So on April 13 of 2023, I responded to a complaint, and the violation was found at 1415 Northeast 140th Street for the new fence that was installed without a permit. I asked the property owner to obtain it after the fact. I posted a notice to appear on October 1st of 2024. The notice to appear was mailed on October 7th, and my final inspection on October 21st of 2024, and there has been no permit.
Okay, I see the fence. Can you show me the gate?
It's at the front. Yeah.
Okay, so there's a fence and a gate.
The gate was already there.
I know, I just don't have a picture of it. I want to see what it looks like.
Those are the pictures, Magistrate.
Okay. When were they installed? Do you have any idea?
3-4 years ago, I think so.
Okay.
The back fence. But before we had a chain link fence. So,
Okay.
and,
Okay.
I have dogs, so I need a fence.
Okay. No, nobody's disputing the fact that you need a fence. The issue is that it was put up without a permit, and so you need to get a contractor to apply for a permit, have it inspected, make sure that it's within the code, and then you may need to go to zoning. I don't know what the procedure is, but do you have a contractor, sir?
Yeah, we're going to speak with one today because, like I told you before, we got ripped off. We were trying to do this like a year ago, and this guy just like ripped us off. And now we have no proof because it was all the transaction was all done in cash. So now we're going to speak to another lady.
That was your first mistake.
Yes.
You know, if you already spoke with a contractor, you have a contractor on board, and he or she knows what to do, it shouldn't take very long. What is my
we really want to work with you.
Okay, what is my abatement date, Madam Clerk?
Okay, your abatement date, give me 1 second. I wasn't ready for that one. Is November 19. That's your 30 day. Not October. No, sorry.
No, that's
No, that's not it.
Next week.
Not it. Yeah, that's next week. Today is over. Okay, 1 second. That was the one part I wasn't ready for.
That's okay. It's been a long time since we
Right.
met, so we're a little rusty, and I'm a little rusty, so don't worry about it.
All right, Magistrate. We'll do. Let me write this down myself. Your 30-day abatement date will be December 4th.
Okay. And the 60-day?
60 days will be on. We'll do the 6th of January, but we won't have a hearing on January. The 6th of January, and then February would be
90 days?
the 3rd. It's February 3rd.
Okay. All right. Sir, I'm going to give you until January 6th, 60 days from now, to retain your contractor, apply for an after-the-fact building permit, and get it approved by the city. So that's 60 days.
Can I request something, please? Because I'm not going to be in the country in January 6th. I'll be in Germany.
No.
Okay, it doesn't.
No. Yeah. Be back.
Sir,
Oh no, yeah, no, never mind. Okay, sorry.
that doesn't mean you have to appear before me on January 6th.
okay,
There
okay.
will not be a hearing on January 6th. The reason I say January 6th is that the work has to be
Completed.
permitted, not completed, but the permit process has to be completed by January 6th. Whoever's
Okay.
talking in the background, please cease. if you do not complete the, if you do not get your,
I didn't fill out the payment part because I wasn't sure who was.
Yes.
who's speaking, and please stop the side conversations.
It's in the room behind us.
Okay, well, all right. So this is my order, okay? And if you don't comply, you're going to get fined. All right?
Okay.
You're not getting fined today, but since you've agreed to get the after the fact building permit and you've already contacted a contractor, my ruling is as follows. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the violations still exist, proper notice has been given. I find in favor of the city. Enter an adjudication and set a compliance date of January 6th. That's 60 days from now, 2025. In the event of non-compliance, there will be a daily fine of $250 until the violation is abated or complied with. All right, next case.
Okay, we're finished?
No, it's not.
No, you got two others.
Next case, Magistrate, is item number 10, case number CEBPR 2023-00838. The officer in this case is Gennaro Murillo.
Okay, Mr. Romanuk Nunez, you have also been cited for not having a permit for the shed that was installed in the back of the house. Do you understand that you need a permit for that shed as well?
Yeah. I didn't think I needed a permit for the shed. Because I already had, I mean, it's a cheap shed.
Doesn't matter. You still, any type, under the Florida building code, any construction which exceeds, I believe it's $250, any construction requires a permit. It may be an easy thing. It may not be an easy thing. You may be able to obtain it. Maybe the building official will deem it unsafe. That it needs, if it needs a permit, you need to get a permit. If the building official will not issue a permit because he or she believes that it's an unsafe structure, then you're going to have to tear it down. So I'm not the building official. You're going to have to go to the building department and have someone on your behalf apply for a building permit for a shed. They will go out and they will inspect it and they will look at the plans and see if it meets the code.
Can I ask you something? Can I speak with the contractor that I want to speak with today to do all these procedures?
You can speak with whomever you want today, tomorrow, or the next day. But I'm going to find you. I'm going to find you guilty. But I'm going to give you, again, like with the first violation, I'm going to give you 60 days to decide whether you want a permit and then apply for it. If you cannot get a permit, we're going to make you demolish the structure as an unsafe structure.
Okay.
But you got to build it in accordance with the requirements of the building official.
Okay,
So, Mr. Inspector Murillo, can you tell us what the violation is about? It's Section 532 of the City Code that requires permits for this type of shed. Can you put some facts on the record regarding this violation?
Yes, Your Honor. So this case was opened same day, April 13 of 2023. So the violation was found for not having a permit for the shed that was installed on the back of the property, which the property owner needs to apply for and after the fact as well.
Okay. And the
again,
code, the building code requires a building permit for this type of structure?
Yes, Your Honor.
Okay. You didn't get too close to that dog, did you?
No, Your Honor.
Okay. All right. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set an abatement date of 60 days, January 6, 2025. The event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Okay, let's move on to the third case. This is a roofed terrace that was built without a permit.
Yes. Item number 11.
Yes.
Magistrate, case number CEBPR 2023-00839. Officer Murillo is on the case.
All right.
I'm sorry, this is a pergola. The change was made on the notice of violation. But yeah, this is a pergola you see on the that was built.
Okay, this is a terrace.
Yeah.
Okay. All right, because my file says the roofed terrace. This is not a roof issue.
Yeah, no.
Okay. All right, Mr. Roman Nunez, you understand that that structure, that terrace that is on that photograph also requires a building permit from the city of North Miami, correct?
Okay.
All right, I'm going to give you 90 days to get the necessary permit. You can use the same contractor, a different contractor, or if you know how to do it yourself, you can do it yourself. But we need to see permits on these three cases by January 6 of 2025. So based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 60 days. January 6, 2024 is the abatement date. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Please understand, sir, you're not being fined today. You're not getting a fine. We could have imposed a fine. But under the city code, I have the discretion to give you time within which to comply. But
I appreciate it.
okay, now, I'm very lenient about granting these kinds of extensions. But if you do not follow my order, if you ignore my order, if you come back, if we, next time that we meet after January 6th, if this violation is still in effect, those penalties that I just imposed will start accruing, which means that for each violation, you will pay $250 per day. So I encourage you to get this done quickly. If you can get a building permit after the fact, fantastic. If the building official does not feel that that for example, the shed, he may think that the shed is illegally constructed, and he may not grant you a permit. Or planning and zoning may feel that it's not allowed in your area. Whatever the reason is, if you cannot get a permit by January 6th, I'm going to start accruing penalties, accruing fines. So with that said, I think you got a pretty good deal. So, be happy that you were not fined today. Just go ahead and do the right thing. Okay? Thank you, sir. All right. Next case.
Okay.
All right, Magistrate, the next case I'm going to call is item number 22 through item number 27. The Kissimmee 3205 Shops LLC, case number CEFOB 2021-00045. This case was previously found guilty by Magistrate Smith with an abatement date of April 20 of 2023. The fine was set at $500 plus the $100 assessment cost. You still want me to read one by one, or I can go through it all?
First, let me ask if anyone is present on behalf of the owner.
Yes, we do have Alex Rodriguez here representing this case. Alex Rodriguez, if you can please enable your audio and video.
I think the audio is enabled. Can you hear me?
We hear you. If you can enable your video.
I don't know how to do the video. Hold on. Let me see here.
Are you on a phone, laptop?
I'm on an iPad. It's not giving me an option.
It should be next to the microphone.
It says raise hand, chat, captions, more, but more is just disconnect audio.
On the bottom left corner, it should have a sub-caption with a picture of a video camera. You would click that.
Let me go back to the Zoom. Video. Maybe it's in my settings. I could try to log on with my phone.
Sir, we'll give you a minute. This case or these cases have been around for a while. I'm very familiar with them, and I want to give you, as a representative of the owner, the opportunity to weigh in about and Madam Clerk, we're going to read each one individually because we're dealing with different addresses, different violations, different issues. So I don't want to mix up the the cases. Okay.
No problem.
Sorry, I'm going to try to log on with my phone.
Not a problem, Mr. Rodriguez. While you figure out the camera situation, why don't we move on to the next case, as we do have a pretty heavy agenda, and we'll come right back to Mr. Rodriguez after the next item.
Okay, let's call the next item.
All right, give me 1 second. The next item we're going to call is item number 39. RD Manor Biscayne LLC. Case number is CEMIS 2024-00209. The officer on this case is Gennaro Murillo. And the attendee, I have Adam Watson and Sean Pound. One moment, I will allow you access. Where is Sean? I just sent you the invitation. If you can please enable your audio and video. And is there any other person here to represent this case? RD Manor Biscayne LLC, please raise your hand. All right.
Okay, let's swear in both witnesses, Mr. Watson.
Give me 1 second, Magistrate. I have Emilio Landolfi. Sorry, I'm messing up your guys' name. But if you can enable your audio and video as well. Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
All right, you can put your hand down. My review of the record shows that Sean Pound is an authorized representative. So I have no problem with Mr. Watson. I'm sorry, with Mr. Pound. I'd like Mr. Watson and the other gentleman, Landolfi, to identify yourself and your relationship to the property. Can't hear you, Mr. Landolfi, and I can't hear you, Mr. Watson.
Can you hear me?
Yeah.
Yes, we hear you.
Yeah. What's your relationship to the property?
My name is Adam Watson. I'm a project executive with Kaufman Lynn Construction. I represent the general contractor.
Okay. And what's the name of the general contractor?
Kaufman Lynn Construction. That's KAUFMANLYNN Construction.
Okay. You know that you're not cited on in this case, correct? So you're here as a witness.
Yes, I guess we're the general contractor who's performing the work under the ownership group. Yes.
Okay. I'll allow you to testify as a witness, but you're not the subject of any violation, even though it may have been your company involved. The violation is as to the owner of the property, RD Manor Biscayne LLC. Mr. Landolfi, what is your connection to the property?
I am the owner of the business. Sorry, my English is not very good. I'm so sorry, but I understand and try to speak the better I can. I am the owner of the beauty salon. And in this salon in my salon is the problem with the violation.
Okay. By the way, we have a Spanish interpreter. If Spanish is your preferred language, is it Spanish?
Yes, it's Spanish. I understand you and all of you, but I speak bad.
Well,
I don't.
I can understand you. If you need an interpreter, we have a Spanish-speaking interpreter. If you want to speak through the interpreter, it's fine with me. Let me ask the inspector, Inspector Murillo, is it?
Yes, sir.
This is from what I understand, it's doing construction work after hours. Is that what this is about?
Yes, Your Honor.
And what is the code section that you cited is 5-35C. What are the hours provided for in the code for doing construction work?
That's from 7 a.m. Till 8 p.m.
Okay, and my understanding is that there was some construction work done after 8 p.m., correct?
After 8 p.m., yes, sir.
All right, why don't you tell us about that and who was responsible and what kind of construction work? And from what I hear one of the owners say that he's already got a business there. So was it that business or was it a general contractor? Who was doing the work after hours?
It has to be from the general contractor. I can't give you much of a detail, Your Honor, because I opened this case based on what was sent from DSD, which is Building Zoning. And so, yeah, this case was this happened on October 1st of 2024. And if you see on the...
so sorry.
No, you can't talk, sir. You got to wait your turn.
It's not my case, sorry. It's not my case, sorry.
This is not your case?
Yes, sorry. It's not my case, this.
Okay, then goodbye.
No, later, in another.
Yeah, but for this case, we don't need you, so you can turn off your computer.
Okay, sorry.
Okay, all right. It didn't make sense that there would be ongoing construction and then have someone saying that it was his business who did it. So anyway, is this a project that is ongoing, has ongoing construction going on?
Yes, Your Honor.
What stage of construction are they in?
I can really tell you, but they're doing here like an apartment type of.
So there's nobody renting. There's nobody living there. There's nothing.
No. It's a brand new. Yes.
Okay. I think can you show? You have a picture of the property, correct?
Yes.
Yes. I'll show it to you right now. Yes. Number 39.
Has this been a recurring problem, or this is a one-time violation?
This is the first time that it happened.
And the complaint was made by the building department?
Yes, Your Honor.
Okay, and it was a text that was sent to you. There it is. It was about 8:11. Is that when the violation took place?
Yes. That's where we're still operating.
Where was the construction?
This
going?
is on 1650 Northeast 124th Street.
No. What part of the building was construction ongoing? Do you know?
No, Your Honor, I wasn't there.
Okay, and I see the sign from the general contractor. Let me hear from the GC and whoever else, Mr. Pound, Mr. Watson, either one of you. Can you tell me? Can you tell me what was going on, if anything, at after 8 o'clock on the day in question?
Yes, sir. We had a late concrete pour, and at the time at 8:11, we had concrete finishers still on the job. The concrete finishers typically utilize hand tools, and on occasion they'll use a walk behind finisher, which does make a little bit of noise. We were notified by the city. We filled out the appropriate after hours permit documentation, turned it in. It was approved. We turned in a schedule along with our permit, which identified any additional days from now until the last of the exterior concrete structure work was to be performed after hours. That was all approved by the city, by the building department, and they've approved, I believe it was 8 or 9 after hours pours and finishing activities beyond the 8 o'clock hour. The last of the events will be November 28th, I believe it was. So all of the dates and the after hours permitting requirements have been met and dates approved at this time.
And on the day in question, on this particular violation, you had cement being poured, or you were waiting, the subcontractor was waiting on the pouring to dry? And what was the nature of the activity and the nature of the noise?
Sure. So we had
at 11 after 8 o'clock on that day.
Yeah, after 8 o'clock on that day. So we had concrete had already been poured. We had a late delivery of the concrete material, so the pour ran a little bit late. And at that time, at 8:11, it was only concrete finishers on the job. We were not pouring. Pouring was complete. It wasn't, a significant amount of noise, but, I can understand, they definitely, if code compliance were to drive by, they definitely saw people working there on that day. But it was just concrete finishers. All pours were complete.
But by what time did they all leave the construction site?
They were told to wrap it up. So I think they left around 9 or 9:30, I believe it was.
Okay. Is this the only time that you've extended work hours?
No, sir, it's not. We had concrete finishers that were working past 8 o'clock. This was the first time that we were notified that there was a process and procedure that needed to be followed to perform after hours work. So like I had mentioned earlier, after the notification, we filled out the appropriate after hours permit documentation for any work to be performed after 8 o'clock. We identified the schedule in which the after hours work would happen, and that was approved by the building department. So yes, we did perform work after hours. We didn't know that there was a procedure. We followed the procedure as soon as we were notified, and going forward, all after hours work has been approved at this time.
What kind of construction is ongoing? Is this a mixed use? Is it commercial? Is it residential? What is it?
It's a mixed-use project, residential and commercial.
Are there abutting neighbors?
No abutting neighbors, no.
Okay. Look, I appreciate your good faith and frankness, and I usually find folks who deliberately ignore the code and who are not sensitive to the needs of the surrounding community. I appreciate the fact that you inquired as to what the proper procedure was and are going to follow that procedure carefully. I hope that I don't see you again. I hope that you comply strictly with the requirements of the city, being that we're talking about something that is, in my mind, de minimis, 11 minutes after the hour, and frankly, you complied. You didn't give him a hard time. In this particular case, I am going to dismiss it, and I will be looking to you next time if this happens again. I will seriously consider imposing a very high fine now that you know what the requirements are. So on this particular occasion, I'm convinced that based on the fact that it was only 11 minutes and you didn't know and you already done the right thing. No neighbor complained. It was a complaint by the building department. Based on that, I'm going to dismiss it. So have a great day, and hope that this doesn't happen again.
Thank you, Your Honor.
Thank you. Mm-hmm.
All right, Magistrate, we're going to go back to the Kissimmee property, item number 22 through item number 27. Mr. Alex Rodriguez, are you able to enable audio and video? Alex Rodriguez?
The microphone is off.
Yes, we need your video. Perfect. Thank you. Mr. Rodriguez, if you can please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Perfect.
Mr. Rodriguez, please tell me what is your relationship to the ownership of this property?
I'm the Vice President of Construction for IMC Equity, who owns this property.
All right, let's get the terminology correct. The owner of this property, according to the city, is Kissimmee 3205 Shops, LLC. Are you saying that IMC Equity is the, I don't want to say owner, but the managing partner, or what?
Yes, it's one of our LLCs, and we manage the property.
Okay. Is this an out-of-state corporation?
No, we're here in North Miami.
Okay. And what is the address of the corporation, of the LLC? Kissimmee.
696 Northeast 125th Street. We're a couple blocks from the city hall.
Okay. And you're in charge of construction. What construction is ongoing at these properties?
There's no construction ongoing. We purchased these properties, I believe it was back in 2021. And there was some rezoning happening, and we're very happy that finally took place in September, and we applied for our CU right after. I'm in the process of getting the CU. I'm working right now with Marcellin
Hopefully we'll have the CU in the next 20, 30 days. Zoning, I'm submitted right now with Durham for these 3 properties. Once I have the CU approved, I'll submit for the BTR, and hopefully the case is closed at that point.
We all hope that.
Yes.
Let me see if I understand this correctly, because this has already come before me, and I found you guilty well over a year ago. During that period of time, was the property being used as a rental? Is that?
Yes.
Okay, so you had tenants using what used to be college dorms.
Correct.
Okay, after Johnson and Wales left, students left, these were empty, you acquired the title. When I say you, I mean the ownership group. You
Yes.
acquired the property and you started renting. What were you thinking?
Well, we were told that we tried to rezone them, and then we were told that the city was going to take over the rezoning process. And I think last time we met about a year ago when I got involved in this, they were in the process, and we were able to get it completed in a couple months ago in September. So now we're going through to get the CU and the BTR.
Okay, so the city rezoned the property from what to what?
It was rezoned from, I don't have the terminology in front of me, but basically a dorm to commercial.
Before I ask the city, and this is one of the violations, that it was a prohibited use in a non-residential district, and it needed to be zoned to PU, which is public use. Do you agree with that?
I would lie if I told you I know exactly what it was.
All right, you're not a zoning lawyer. I don't
No.
expect you to know that, but the units were being rented illegally because you had a zoning use that was not compatible with what you were using it for.
Correct.
Okay. What took you so long to seek the zoning change?
No, we tried immediately as we purchased it, but then the city said, no, since it's so many properties, this is what I was told, since there's so many properties, we're going to take the lead on it and we're going to have it rezoned. So we were basically waiting for the city to go through the rezoning process so that then we could apply for our CU.
Where are the managers of the LLC, Alan Lipton and Yoram Yitzhak? Where are they?
Yoram is here in the office. Alan is an investor. He's not here.
Okay. Is Yoram with you?
No, he's not here. Right now in my office with me, no.
Okay. They had an opportunity to come and explain this to me back in April of 2023 when I entered when I set my the abatement date and my hearing on March 2nd, 23. Nobody showed up, which is it's not a good thing when you want relief from the city.
I understand that would somehow no excuse, but I think I came the next hearing when I was finally given the notice. I didn't have the notice, but I got it, I think, in the next hearing, and we met. I don't remember if it was 9 months ago or 10 months ago.
Okay, I'm not happy with the way this case was handled by your organization. I think that at the very minimum, one of the principals should have had enough respect and good faith to show up and explain the zoning process and what was happening and why were these units being rented in a manner that violated the zoning code. I'm usually pretty lenient when it comes to people that are trying to work in good faith. I am not lenient at all with people who just ignore magistrate orders don't even show up. And I'm not blaming you, sir, necessarily. I'm not blaming you. I'm blaming your bosses for how long it took to respond. And I don't recall seeing you at any meeting. I may be wrong. I don't recall everything, but I know that for many, many months, even years, since Johnson and Wales went out of business, this property has been used in violation of the zoning code. And I don't take lightly. All you had to do a couple of years ago, year and a half ago, was come in and say, look, we're going to discontinue these leases. We're not going to lease these properties, and we're going to apply for a zoning change. Nobody ever came to me for that. So that expresses my thoughts on where I'm going to be going forward. And you know, you're here today telling me you're going to get this, you're going to get that, you're going to get the other. Let me hear from the inspector and ask that the inspector explain where we are, what he knows, and what is the recommendation of the city on these violations, which have already resulted in a finding of guilt and fines accruing since April of 2023. I want to hear from the city.
Good morning, Magistrate Smith, Neighborhood Service Inspector Jonathan Lemestry. And as you're aware, this case was found guilty by you on April 20th, 2023. This case was first opened on November 8th, 2021 by our current manager, Jose Perez. They have not obtained the certificate of use as of November 6th, 2024. They have not obtained...
Wait.
Yes.
We're on case 22, which is the BTR.
Okay, so for case number 22, they have not applied or obtained a business tax receipt for the property 13025 Emerald Drive. There's nothing on file.
Okay, and obviously they can't get a business tax receipt because they didn't have the zoning, right?
Correct, and they don't have a certificate of use as well. So I've been told that they have not obtained the zoning yet. I actually visited the zoning department this morning. I spoke to Marcelin Francois. He told me that he was unaware if this property, 13035 Emerald Drive and 13025 Emerald Drive, if they have the zoning approved. So, you know, he's stating that it has been approved, but he has failed to provide proof to the city that it has been approved. So he's stating that it's been approved, but I haven't received any proof of that. As for the certificate of use and business tax receipt, Marcelin Francois, he is in charge of the certificate of use. He told me that the property owner has not even applied for a certificate of use as well.
Okay. So let's do, by the way, any response, Mr. Rodriguez? Do you have a copy of a zoning order or anything showing that the property has been rezoned?
So we were following up with Debbie Love, Development Service Department, Director of Development Service Department, and she was the one that notified us that it had been approved. And at that point, she said you can now apply for your CU, and she copied Marcel on the email. I went through the CU documents, and one of the items was submit to zoning, and I did submit to zoning. DERM for approval. I have that process number. I provided it also to Marcelo, so he has those process numbers. It's for 3 properties, 2 Emerald and 1 Lakeside. During from the last time we met for the magistrate meeting till now, Mr. Jose Perez, I've been following up with Debbie and forwarding her emails on a monthly basis to him, and he's reviewed them and granted us extensions every time. So we have been very, very open book and trying to get this resolved, but we really haven't. We've been following the city's lead on this. So now that, well, she had stated that it was approved. That's why we were going through the process of getting Durham approval, and then once we have the CU, we're going to pull the BTR immediately after. So
this is all nice that that you're moving along. By the way, Durham hasn't approved it yet, have they?
No, they asked me for a section of the application to be filled out by the city, and I sent that over to Marcelo this morning as he told me that it was one of the pages that I had not included. So he asked me for it, and I had sent it to him this morning. So they're filling that out now.
All right. I'm going to rule first on case number 22, which is the failure to obtain a business tax receipt for 13025 Emerald Drive. I am going to rule that based on the testimony of the city's code enforcement officer, the evidence presented showing that the property has been out of compliance since April 20th, 2023. And by the way, we need to spell April correctly. All right, it's misspelled all through the page each days. Anyway, the out of compliance is April 20th, 2023. I find in favor of the city, hereby ratifies accrued to date as set forth in my previous order, and assess costs in favor of the city. The said fines shall continue to run on a daily basis until there is compliance. On number 23, it's the same.
Magistrate, we didn't read those into records. We didn't read any, Magistrate, we didn't read any of the other cases into the record. So
okay, so let's do number 23 now.
Yes. Item number 23, Kissimmee 3205 Shops LLC, case number CEFOB 2021-00048, found guilty by Magistrate Smith with an abatement date of April 20, fine set at $500 plus the $100 assessment cost.
Okay, Mr. Rodriguez, you don't have a business tax receipt yet for the property in question at 13035 Emerald Drive, correct?
Correct. I can't apply for it until I have the CU. So.
Okay, and that's a violation of section 11-19. Also a violation of my order entered on March 2nd, 23, based on the unrebutted testimony of the city's code enforcement officer and the evidence presented that the property has been out of compliance since the abatement date of April 20th, 2023. I find in favor of the city and hereby ratify the fines accrued to date in the amount of $500 plus cost assessment of $100. The said fines shall continue to run on a daily basis until there is compliance. Let's move on to number 24.
Kissimmee 3205 Shops LLC, case number is CEZCU 2021-00189, previously found guilty by Magistrate Smith with an abatement date of April 20, 2023, fine set at $500 plus the $100 assessment cost.
Okay, Mr. Rodriguez, you don't have a certificate of use for the property at 13025 Emerald Drive, correct?
At this moment, it has not been approved, no.
Right, and I want to hear from the city. Is there a certificate of use for the property?
No, sir.
Okay. Based on the unrebutted testimony of the city's code enforcement officer and the evidence presented showing that the property has been out of compliance since the abatement date of April 20th, 2023, I hereby find in favor of the city, ratify the fines accrued to date in the amount of $500 plus $100 cost assessment. The fines shall continue to run on a daily basis until there is compliance. And I believe the next one is
number 25. Kissimmee 305 Kissimmee 3205 Shops LLC. Case number is CEZCU 2021-00192. Previously found guilty by Magistrate Smith with an abatement date of April 20, 2023. Fine set at $500 plus the $100 cost assessment.
Mr. Rodriguez, this is the property at 13035 Emerald Drive. No certificate of use yet, correct?
No, it has not been approved.
Okay, sir. Mr. Officer Lemestre,
Yes, sir.
what can you tell me about this violation?
Again, for the certificate of use, he does not have one. According to his word, that he has applied for it, but again, until he has the Durham approval, the application can't be accepted. So he would have to get a Durham approval first in order to submit the application.
He would have to get the right zoning also, correct?
Correct.
Okay, it's not just, the Durham is not holding him up.
Correct.
Okay.
No.
Anyway, based on the unrebutted testimony of the city's code compliance officer, the evidence presented showing that the property has been out of compliance since the abatement date of April 20th, 2023, I find in favor of the city, ratify the fines accrued to date in the amount of $500 plus a cost assessment of $100, and assess and also further rule that the fine shall continue to run on a daily basis until there is compliance. 26.
Kissimmee 3205 Shops LLC. Case number is CEZPU 2021-00053. Found guilty previously by Magistrate Smith with an abatement date of April 20, 2023. Fine set at $500 plus the $100 cost assessment.
Okay, is the Assistant City Attorney present?
Yes, she is.
Okay.
Yes, Special Magistrate, I'm present.
Could you identify yourself for the record, please?
Assistant City Attorney Paul Marie Bob.
Okay, Ms. Bob, could you put on the record the code section that governs the use of this particular property? What was it being used for? What is the right zoning? Could you explain the zoning situation so that the record is clear that there was a violation in the zoning laws?
Well, I believe that the inspector cited 23-3-215.
Well, that's the certificate of use. I think you need to look at 29-4-302, which is the violation cited. This is the violation that was cited in case number 26. That was the prohibited use in a non-residential district.
Oh, my apologies. I was still on 25.
Yeah, we're on 26. The violation is prohibited zoning usage. So I'd like you to explain what that means in plain English so that everybody understands what led to these violations and what the code says with respect to the use of this property.
Okay, 1 second. So code section 29-4-302 states planned development districts PD1, PD2, and PD3. A purpose and applicability. The purpose of the above listed planned development districts is to provide a means of promoting greater innovative and creative development of land, ensuring that the location of mixed use development outside of the NRO is appropriate and compatible with adjacent land uses in accordance with the goals, policies, and objectives of the comprehensive plan, to promote a more desirable community environment through approval as the rezoning and the issuance of conditional use permit. A planned development district shall not be approved in an R1 or R2 district. Development standards. The City Council may approve a planned development subject to compliance with the development criteria and minimum development standards set out in this section. And it lists a group of items that they need to comply with in order for the council to approve a planned development.
Okay, so in essence, and the inspector who cited the section perhaps can weigh in on it, the use of these units, which previously were part of Johnson and Wales University, when that use went away, when the university went away and it was no longer considered student housing, and when the use was changed to apartment rentals, that is what created the violation under that section. Is that what you're saying, Mr. Inspector, Madam City Attorney?
That's correct, which is why I'm under the impression that they were trying to get the use changed, which I believe he stated that the city was in charge of changing the use for that whole area.
Good morning. Jose Perez, manager for the Neighborhood Service Department. I was the one that originally cited this property, rather two folios, as it relates to the subsequent violations. In essence, the violation came forth when the zoning department notified us that the two buildings were being rented out already to the community as private housing rather than public housing. In essence, the zoning at that time in 2021 and to current was public PU, so for public use, which would prohibit that housing be rented out for profit by a private company. Therefore, the subsequent violation of the zone prohibited use was applied in this case. Since the zoning hasn't been changed, that's why the violation still exists. Once the zoning has been ratified, then that would cure the subsequent violation.
Do you know if do you know whether the Planning and Zoning Board has met to consider the zoning change?
I do believe there have been some meetings. However, I do know also that the meetings have been postponed recently. I don't necessarily have notification that this specific item passed or did not pass. Mr. Alex Rodriguez did share some emails with us as it relates to notifications from Ms. Debbie Love. However, the last notification that we received in July pretty much just states that they hadn't received the word yet from the state as it relates to ratifying it, because I do believe the state has to ratify it, based on my understanding. I'm no zoning expert, but that's the two particular interest that was expressed to me. In that case, that's why, since we haven't received any further notification from Mr. Rodriguez, this case came back by Inspector Lemestre.
Okay, I think when you talk about the state, you're talking about an amendment to the comprehensive plan, which would have been required before the zoning change goes into effect. Even if the city commission or the city council approves the zoning change, it still has to be ratified in the comprehensive plan, which goes to the state, and the state has to say yes. So is that more or less what the process is right now?
Yes, sir.
Okay, now that these properties are being still rented, or are the old rents still in effect, or are there ongoing rentals going on?
Based on my understanding, the properties are still being rented out, but I will defer to the defendant, Mr. Rodriguez, to provide.
Mr. Rodriguez, are you still renting these properties, or are these the original leases that were made a couple of years ago?
I don't know if leases has changed, but yes, the buildings are occupied by the renters.
Okay, all right. Nonetheless, well, I heard much of what you said. I don't know that it makes any difference. Those leases are in violation of the code and are invalid. So, you know, we'll let the legal system deal with that in the future. But with respect to we're on 26, correct? Or 25?
Correct.
All right, 26. That's why I wanted record evidence of the zoning issue. So as to item 26, based on the unrebutted testimony of the city's code enforcement officer and the evidence presented showing that the property has been out of compliance since the abatement date of April 20th, 2023, I find in favor of the city and hereby ratify the fines accrued to date in the amount of $500 plus $100 in a cost assessment. The fine shall continue to run on a daily basis until there is compliance.
All right. Number 27.
27.
Item number 27, Kissimmee 3205 Shops LLC. Case number is CEZPU 2021-00054. Previously found guilty by Magistrate Smith with an abatement date of April 20 of 2023. Fine set at $500 plus
Okay,
$300
so
cost.
this is the mirror image of the prior one, which is 13025 Emerald Drive. This one is 13035 Emerald Drive. Prohibited zoning. So, Mr. Rodriguez, you understand that until you get the correct zoning in place, you're gonna be fine as per my prior order of March 2nd, 2023. Correct?
I understand.
All right. Officer Lemestre.
Yes, sir.
Why don't you tell me a little bit more about that particular property, which is at 13035 Emerald Drive, and the violation that you cited, prohibitive zoning usage, PU zoning. Tell me about that.
Yes, sir. So again, on November 8th, 2021, our current manager, Jose Perez, opened a notice of violation in regards to the property operating as a apartment rental, without getting approval from zoning. They have, since day one, since November 2021, they've been operating as a rental without city approval. So as of November 6, 2024, again, I literally just got off the phone with Debbie Love, who is our director of zoning. She informed me that they were approved for the zoning change, but it's not in effect yet. They're not allowed to change it to rent at the moment. Were they approved? Yes, but it's not in effect yet. And
who did the approval?
The director of zoning, because I literally just got off the phone with her.
Doesn't that require a hearing before the Planning and Zoning Board?
I
That
believe
would be
so,
correct. Yes.
Yes.
Madam City Attorney? Ms. Bob?
Yes, I'm here. That is correct. I'm assuming that they may have already had the hearing, but only Debbie Love would be able to answer those questions, being that she's the one who's informed Inspector Lemestre that they were approved but are pending. What did she say was pending, Inspector?
She was waiting for the date of when they would be able to do the rental at the apartment.
Okay.
At the apartments.
But not yet.
Not yet.
But not
no,
yet.
sir. Not yet.
Okay. All right. Based on the unrebutted testimony of the city's code enforcement officer, the evidence presented showing that the property is out of compliance, has been out of compliance since my order of March 2nd, 2023, I find in favor of the city. Hereby ratify the fines accrued to date in the amount of $500 plus $100 in costs. And I assess costs in favor of the city. The fines shall continue to run on a daily basis until there is compliance. Now, let me just say to you, Mr. Fernandez, and also to the ownership group. I'm sorry, Rodriguez, Alex Rodriguez, and to the ownership group. I'm compelled to order the way that I did based on the laws that I have to follow. Your group, the ownership group, has the right to go and meet with the finance director, the city manager, others, to seek mitigation. This city does not allow the special magistrate to mitigate. That would be a totally separate hearing. So if you're able to show good cause and you're able to show that you move diligently and satisfy the city manager or finance director, whoever it might be, you may be able, you have an opportunity to have these fines mitigated. But I am not allowed to do that. And so once you have your appropriate zoning change and everything is in place, legalizing the use to apartment rentals, then even though these fines will probably lead to a lien against the properties, you do have that ability to file for mitigation. So I encourage you to continue to work in good faith with the city, because your good faith will help you at some point perhaps reduce some of these fines, or at least eliminate some of them. So I have no choice but to impose the fines, and I did. So that's all I can do. I can't consider a mitigation request at any time. That has to be done by the city. So with that said, thank you very much, sir. I appreciate the fact that you now apparently do have it, although it's not in effect yet. Hopefully we can resolve this with your organization, because we're all neighbors here. We want you to be sensitive to the community and to the city and to follow the laws. And so that's why this process has now come to an end, as far as I'm concerned. And I look forward to your continued cooperation and treating your neighbors the right way. So with that said, thank you. Let's move on to the next case.
All right, Magistrate, the next case we're going to call is item number 12, Eldar Limited Co., case number CEBPR 2024-00046. The officer on this case is Shanna Sanders. I do have two attendees here, Crystal Esperanza and Guillermo Hanfling.
Okay, I'm getting an echo. Is there a mic that's open that shouldn't be open? Okay. I'm still getting an echo. Okay, I know who Guillermo Hanfling is. He's listed as the manager of the corporation, Eldar Limited Corporation. Is that correct, sir?
Yes.
All right. And this is a shopping center?
Yes.
All right. Tell me your relationship to the property. Is it Crystal Esparza?
Yes, I'm sorry. We're sharing the same office. I'm not sure if I can the same Zoom link.
If you have two devices open at the same time, you're going to get feedback. You're going to get.
You muted, McGorry.
All right.
Esperanza, yes. Yeah, that's what I was going to say. But we're still getting feedback. Yes. Okay. All right. If you, Esperanza, Halfling, and Emilio, if you can please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say, I do.
I do.
I do.
Thank you. You may put your hands up.
All right. I think I recognize Emilio from a prior hearing.
Yes, sorry about that.
Okay. You, sir, you had told me that you were the shop owner?
Yes, I do.
Sir, you own a shop at this shopping center?
What? Sorry.
You have a business in this shopping center?
Yes.
You own a business?
Yes, it's a beauty salon.
It's a salon, okay. It's at 16141 Biscayne Boulevard?
Yes. One.
Okay.
16141 Biscayne Boulevard.
Okay.
Emilio, you have two devices on.
No, only one.
the echo appears to be coming from Crystal. She's sitting next to Guillermo, who are both on. If maybe one of you two could mute yourselves, that way the echo doesn't come forward. Thank you.
Just mute yourself, and we will be able to hear you since you're right next to each other. Okay, so Crystal Esparza, what is your relationship to the property?
Crystal.
Okay, can you hear me now?
Yes.
Yes, okay. I'm the office manager, and Mr. Hampton is the managing director for Eldar.
And Guillermo Hanfling is who, the owner? Guillermo, can't hear you.
I am sorry. I don't speak English very well. I need only Spanish. Okay. Crystal is my manager in the shopping.
Okay, can I have the Spanish interpreter interpret that? I think he said that Crystal is the manager on this property.
Solo para confirmar, Crystal es la encargada de la propiedad, ¿verdad, señor Guillermo?
Es correcto.
That's correct.
Okay. All right. Now we know who's who. I want to hear from the inspector, Shanna Sanders.
Shanna Sanders, City of North Miami, Neighborhood Service Inspector. I originally cited and opened up this violation on March 21st of 2024, whereas I received a call regarding different activities that was taking place at the facility. I visited the facility. I spoke to the owner of the business via telephone call, who indeed confirmed that some work was done without permits. He stated that he would proceed to the city to fill out the necessary permit applications, which indeed he did. As of today, the permit applications were submitted to the city 2 months later, in May. It shows exactly May 27th to be exact. And after that, the permits were denied 2 days later. No activity has been made with the permit application. It's been, again, sitting in the building department since May. So I moved forward with presenting this case since the work was indeed done and no permit has been obtained. I've spoke with Crystal in the contractor of the job who did the installation, and again they have been stating they're trying to move forward with obtaining the permits, but again nothing has been obtained as of my last reinspection. So here we are today presenting the case. I am showing it. Okay.
Can you please, I remember reviewing the file. I just want to make sure that it's the same file that I think it is. Can you show me the plumbing work that was done without a permit? Can you show me some pictures?
Yes, Magistrate, give me 1 second.
While you're doing that, I'd like the Spanish interpreter to explain, to tell the two individuals that have problems with the language, so that they can understand what the violations are about. Madam Interpreter, please let Guillermo and the other gentleman, forget his name, Emilio, tell them what the inspector just said.
Ahora que sabemos quién es quién, le doy la palabra a la inspectora, la señora Sanders. Soy del norte de Miami, servicio del vecino e inspectora. Abrí este caso el mes de marzo, 1 de marzo 2024, sobre diferentes actividades que estaban tomando a cabo en este lugar. Hablé con el dueño a través del teléfono y confirmaron que sí estaban haciendo trabajo sin permiso. Declaramos que necesitaban ir ante la ciudad para poder aplicar para permisos, cual hicieron. Ahorita el permiso, de hecho, lo hicieron 2 meses después, a fecha exacta 27 de mayo. después de haber aplicado para los permisos, fueron negados. No ha habido ninguna actividad desde que se hicieron dichas aplicaciones sobre el departamento de edificio. Desde entonces, a mayo, decidí yo seguir adelante con este caso, ya que ningún trabajo se estaba haciendo. Con permiso, hablé con Cristal y hablaron sobre la construcción, sobre la instalación. De nuevo intentaron hacer el permiso, pero ya que nada se ha podido hacer, seguimos adelante con este caso. Recuérdeme, dice el magisterio, sobre lo que se estaba archivando, el trabajo de plomería que se estaba haciendo sin permiso. En un momento le explican.
That was a great job, Madam Interpreter. You got it all right. I can't, I can't do it any better. I'm fluent in Spanish. I can confirm that everything she interpreted was exactly, I don't know how she was able to do it, but almost word for word what Inspector Sanders was testified to. Anyway, do you know, Madam Inspector, what the problem was with the building department, why they couldn't get the building permit issued?
From what I recall, they submitted, the plumber submitted the application stating that all he did was plumbing work. I believe they denied it because they're stating that now once work was done, in addition to the plumbing, they needed to obtain electrical and or building permits as well because the ground was messed with, and now they had to upgrade the electrical, seeing that again they had to bring it up to code with everything now, since they couldn't just apply for the plumbing, they had to do electrical and building.
Okay, so it's not only a plumbing issue, it's now more complicated than that. They need an actual building permit for other construction that took place in addition to the plumbing. So, Madam Interpreter, can you interpret that?
Bueno, sigue adelante, señora inspectora, sobre qué es lo que sucedió con el departamento de edificios y por qué no se le pudo otorgar dicho permiso. Por lo que recolecto la aplicación que se hizo ante el plomero, dijeron que se negó porque tenían, ya que ya se había terminado la plomería, lo negaron y declararon que necesitaban también obtener permiso de eléctrico, al igual que del edificio, porque se movió el piso y ahora tenían que actualizar también, codificar la parte eléctrica y el edificio. Suena más complicado, dicen, aparte de tener el permiso del edificio en adición con la plomería.
In addition to that, Magistrate, they're also requiring that they go to Durham. I don't know exactly for what, but I did see a comment on there mentioning they need to visit Durham as well and obtain their approval.
Okay, because it involves water.
Mm-hmm.
Okay, and Durham oversees the water issues. Madam Interpreter, I don't know whether you know what Durham means, but can you interpret what the inspector just testified to?
En adición, también tengo entendido que necesitan visitar Durham, no sé para qué, pero necesitan obtener aprobación por ellos también. Sí, dicen, necesitan ir ante ellos porque ya es un problema con agua igualmente. Ellos se involucran cuando tienen que ver agua.
Okay, that's the case against the owner. I would like somebody from the ownership group or their representative to tell me how much time they will need. But number one, whether they already have someone working on this. Two, are they aware that the work that needs to be the work that needs to be permitted? Number three, how long will it take for all that work to be done, understanding that Durham can take a couple months at least to approve some of these construction projects. So who's gonna respond from the ownership group? Mr. Landolfi, do you want to tell me what the answers are?
Yes, and if Crystal, you can help me if my English is not very good, but we understand the violation. Really, I didn't know when when I do it, and I want to fix it. Okay. Before that, I am working with Shisi, a general contractor, to resolve this. We have the permit in the Crystal conduct, in the conduct of in the county. Sorry, we already have the permit, and when with this permit finish, we can go to the City of North Miami to have our permit to fix this problem. I don't know if, sorry, my English is not very good, but
I understand you.
I tried the best.
Let me just stop you, sir. How much time do you think you're going to need to get everything done? How much time do you want?
I think it's possible 90 days, 90 days. 3 months is possible. 90 days for finish all the.
Are you saying that within 90 days you'll be able to get all your permits, including Durham, and and have everything approved? Yes.
I hope that. If you can give me more time, for me, I want to finish this most quickly possible.
We're not bargaining. Okay, I am asking you, what is the fastest way to finish the job with all the permits you need and be done with this? How much time will you need to get everything done? I'm not giving you more than 90 days.
Okay, 90 days.
Magistrate, if I can, and I'm going to jump in for Mr. Emilio and for Crystal. We had a conversation yesterday because they called me asking me for an extension, and like I told them and explained the day before the hearing, we're not at liberty to give extensions. I am jumping in because they just submitted the application to Durham yesterday, which they showed and submitted to me. So I would, be comfortable with saying 90 days. If that's the most you're willing to give, let's go with that, because again, it was just submitted yesterday to Durham, and as we know, Durham takes well over 2 months, sometimes maybe 3, to even review a case. So let's go with 90 days if possible.
Yeah, that's what I'm going to do, but I'm always concerned about public safety. Life safety issues are very important, and Madam Interpreter, I want you to be very, very accurate in what I'm about to say. I would like the building department to go out there, look at the work, the plumbing work and the electrical work, and make sure that there are no life safety issues with respect to their customers. There's a lot of water in a salon. If there's an electrical issue or potentially a plumbing issue that could affect the life safety of the customers, I'd like to make sure that the building official is aware of it, and if necessary, shut down the business if there's an emergency situation or a life safety situation. In the meantime, I'm okay with the 90 days. Madam Interpreter, why don't you translate what I just said, and I want the owner in particular to hear what I just said.
I'm going to interpret everything that was said. Interpretaré todo lo que se acaba de decir. En este caso, el dueño con alguien más del grupo de dueños quiera representar o decirme alguien que trabaje con esto. Uno, si ya tienen a alguien que está trabajando en estos dos, si ya están al tanto de qué trabajo se necesita hacer para tener permisos. Y 3, cómo es que todo este trabajo y tener el entendimiento que Durham más probable va a tomar meses a ser aprobado la construcción o proyecto. Alguien del grupo de dueños me puede explicarlo. Señor Emilio Ladolfi menciona Entendemos la violación, no sabía cuando lo hice, lo quiero arreglar. Estamos trabajando actualmente con un constructor en general, queriendo recibir permiso por parte del condado. En cuanto tengamos dicho permiso, iremos ante la ciudad del norte de Miami para poder arreglar el problema. ¿Cuánto tiempo necesita, menciona el magisterio, para poder terminar con todo? Si es posible, si se me lo otorgan, 90 días, 3 meses. Me estás diciendo que en 90 días todos los permisos, incluyendo DERM, será todo aprobado. Estoy en esperanza que sí menciona, o si me pueden otorgar más tiempo, posiblemente. No estamos así para eso. Necesito saber cuánto tiempo creen necesitar para poder terminar con este trabajo. No voy a otorgar más de 90 días. Voy a hablar la inspectora Sanders por parte del señor Emilio y la señora Cristal. Habían hablado un día antes de esta audiencia sobre una extensión y había yo mencionado que no tenemos la libertad de hacer dicha extensión, y la aplicación del term, de hecho, la acaban de entregar el día de ayer. Entonces yo estoy cómoda con 90 días para ver si esa es la moción que se va a otorgar el día de hoy, porque sabemos que DERM usualmente toma 2 meses, quizás 3 meses para revisar un caso, así que 90 días estaría cómoda yo con que se otorgue. Muy bien, dice el magisterio, ha hecho eso, pero siempre tengo yo una preocupación sobre la seguridad pública. La seguridad de vida es muy importante y quiero asegurar que la señora intérprete diga estas palabras correctamente. Me gustaría que el departamento de edificios vaya hacia ellos y miren el trabajo de plomería, el trabajo de electricidad, asegurar, que no haya ninguna preocupación de seguridad de vida o seguridad ante el público. Sí, solo por el respeto de sus clientes. Hay mucha agua en el salón de belleza, y si hay un problema de electricidad o potencialmente un problema de plomería, no queremos ese riesgo ante los clientes. Entonces se tendría que clausurar todo, pero quiero que tengan o estén al tanto de eso. Primero, ante todo, la seguridad pública. Y ahorita estoy otorgando 90 días para que se puedan recibir dichos permisos, y quiero asegurar que todos entiendan las últimas palabras que tuvo que decir el magisterio Smith.
Okay.
Bueno,
Yes. Any response?
Es claro lo que usted está otorgando el permiso, pero mi pregunta como propietario de la propiedad es, los permisos en DERM generalmente se toman mucho más tiempo. Entonces, en caso que DERM se demore y se llegue a los 90 días y no haya hecho ese trabajo, ¿se podría suspender esa sección que el señor Emilio hizo sin permiso?
I'm going to translate, Madam. Let's have the interpreter do it. That's her job. Go ahead. The question essentially is, what happens if term is delayed and doesn't respond within the 90-day period? Is that pretty much it?
If it takes longer and it passes the 90 days, what would happen? Would the section be suspended? Would Mr. Emilio's section be suspended? That's the question, essentially. If the 90 days pass and DERM has not done nothing yet.
Okay, sir, if you're moving in good faith and doing everything possible to get the permits approved, you can come back at a later date and ask me for a further extension. I hope it's not necessary. I hope that DERM, DERM, everybody thinks DERM is some crazy bureaucracy that deliberately stops people from, moving their projects forward. They do take their time. I agree, they do take their time. But a case of this nature shouldn't take longer than 90 days. I've worked with Durham before. I know what they have to go through, and it shouldn't take more than 90 days. But if you need more than 90 days, I'm open to giving you a little bit more time, provided that you are moving as quickly as possible to get your permits approved. Madam Interpreter.
Si ustedes se están moviendo en buena fe, y todo es posible de que los permisos se aprueban, pueden ustedes regresar en una fecha ya más tarde y pedir una extensión a futuro. Tengo la esperanza de que no sea necesario. Con esperanza, porque todos creen que Durham es una burócrata loca y sí toman su tiempo, estoy de acuerdo con esa parte, pero en estos casos, en este caso en particular, la naturaleza del caso no toma tanto tiempo más que 90 días. He trabajado yo con Durham antes, sé lo que ellos tienen que atravesar y no debería tomar más de 90 días, pero estoy yo abiertos, les digo ahora que estoy yo abiertos a darles un poco más de tiempo. Sí, es que ustedes se están moviendo de manera rápida para poder tener la aprobación de dichos permisos que son requeridos.
Yo soy el más interesado en que eso se haga con los permisos necesarios. Nosotros como administradores de todos los otros locales estamos muy pendientes de que no tengamos ningún problema con la ciudad de permiso o que se esté haciendo algo ilegalmente. Nosotros queremos que todo sea legal, que sea hecho con todos los permisos necesarios. Por favor, dígale al señor juez.
Ya lo entendí perfectamente. Ella lo va a repetir para que todo el mundo lo entienda, pero yo lo entiendo perfectamente. Ma'am, please explain.
I am the most interested to get all those permissions necessary done. Us, the local owners, are all aware and do not want to have any further problems with the city. We don't want any permissions or to get anything done illegally. We want to get this done, all of this done legally, and we want to get all of the permissions that are necessary to get through.
Okay. Last comment, and then we'll close. When the application for an after the fact building permit for the plumbing was made with the city, the building official determined that the scope of the permit needs to be more than just the plumbing. There are electrical issues and construction issues, so a new application is going to be necessary. It's not only Durham.
And Magistrate, they have already submitted the new application for that work to be done. They've submitted it already.
Okay, well, just wanted to be sure that they have submitted the right permit application covering all of the trades that are necessary.
Okay. Último comentario y clausuraremos.
Se fue la señal.
You froze.
Plomería ante la ciudad. El oficial del departamento de edificio mencionó que no solo era parte de plomería, también tenía que ver parte de problemas eléctricos, al igual que el edificio como agua. Entonces necesitamos que sean nuevas aplicaciones para lo que es necesario. Menciona la inspectora que ya todas esas aplicaciones nuevas se han entregado y ya se han hecho. Muy bien, solo quiero asegurar, menciona el magistrado Smith, que tengan entendido las aplicaciones de permiso correctos que se necesitan hacer para lo que es necesario hacerse.
Le agradezco mucho, de verdad. En cierta parte somos inocentes de lo que el TENEN hace adentro, porque no podemos estar las 24 horas fiscalizándoles, pero sí trataremos de que todo se haga en regla. Vamos a hablar con el señor Emilio para que se haga todo. Daremos toda nuestra ayuda como propietarios para que esto se haga. Lo que menos queremos nosotros es tener un problema con la ciudad. Siempre llevamos ahí 28 años y no hemos tenido problemas. Esta es la primera vez que tengo este problema y trataremos de solucionarlo. Muchas gracias.
I've heard from the owner. I've heard enough. He doesn't need to say any more. I heard him clearly. Just explain that to him.
Muy bien, escuché suficiente por parte de el dueño, he entendido, ya no necesita hablar, entiendo perfectamente.
Okay. I just want the owner to understand one last thing. Even though he didn't do the unpermitted work, even though it was done by a tenant, under the code, the owner is always responsible. Always responsible. Even though he may not have known about it, he had nothing to do with it. By law, he is responsible.
Se va a apretar a este señor.
Solo quiero que el dueño sepa una última cosa. Aunque usted no estaba al tanto de ello, aunque fue por parte del inquilino que lo que se hizo debajo del código de ley, usted es responsable, aunque usted no haya sabido. Ante la ley, usted sería el responsable.
No, I don't want an answer. It was just my comment to close, okay? And we've already hashed this back and forth enough time. Let me just enter my order and move on to the next case. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violations still exist, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 90 days through February 3, 2025. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Okay, you want to read that? You want to read that to the owner so he understands?
Muy bien.
And also the property owner? 90 days, and if he doesn't comply by February 3, 25, the fines will be $500 per day.
Okay.
Muy bien, no necesito ninguna respuesta, eso solo fue un comentario que quise decir al final y ahora voy a clausurar con lo siguiente. Hemos dado suficiente tiempo y ahora voy a mandar mi orden. Basado en el testimonio de reporto de parte del oficial estatal y la evidencia probada, estoy a favor de la ciudad y estoy confirmado para dar la fecha de 90 días, otorgar 90 días. Sería hasta el 3 de febrero de 2025. Si no hay conformidad para ya esa fecha, se le estaría dando una multa diaria de 500 días hasta obedecer dicha conformidad.
Okay. I think we're done.
Muy bien, ya acabamos. Hay que seguir con el siguiente caso.
Thank you so much.
You're welcome.
Gracias.
All right, Magistrate, thank you for that. We're going to move along to item number 28. Mona Thorancy, case number is CEBPR 2021-00215. This case was previously found guilty by Magistrate Smith with an abatement date of October 7th, 2022. A fine was set at $250 plus the $100 cost assessment. The officer on this case was Brantley Daniel.
Can we take Emilio off the
yes, sorry.
We're done. Goodbye. All right.
And for this case, we have the attendee, David Thorancy, who's here as well. Mr. David, if you can please enable your audio and video. David, if you're here. I see your hand raised. You were sent an invitation. If you can please accept the invitation and enable audio and video.
All right, let's go. Let's move along.
All right.
If you're not present, we're going to skip over you.
Mr. Daniel, did you wanted to state something in regards to this case?
Yes, McGorry. Yes, Magistrate Smith. Good morning. As far as this case is concerned, compliance was met. The building inspector, Miguel, advised me that the resident was able to obtain the necessary permits or the carport.
All right, so you're asking me to dismiss the violation?
Yes, Your Honor.
All right, based on the fact that there has been compliance, according to the officer and the building department, and I've reviewed the file, there's a lot of work that needed to be done. I am, at the request of the city, I am dismissing the case number, the 28 on the agenda.
Yes, Your Honor.
1145 Northwest 123rd Street. I will dismiss.
Thank you, Your Honor.
Okay.
All right, moving on to item number 20, ICP Premier LLC, case number CEBPR 2023-000940. The officer on this case is Jamie George. I also have the attendee Mariana Cabrera, as well as Julio Martinez. If you guys can please enable audio and video and raise your right hand. Julio and Mariana, please accept the invitation and raise your right hand.
There we go.
All right. I have Mariana and then Julio. If you can enable your audio and video.
Will you be
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Do you guys need any translator?
No.
Okay. First, let me ask Mariana Cabrera, what is your relationship to the property?
I'm the representative for the owner as well as the property manager for the owner.
And Mr. Martinez, what's your relationship to the property?
Mr. Martinez, you just muted yourself. You were fine before.
Can't hear you now. Okay.
Can you hear me now?
Yeah.
Yes.
Yeah.
Okay.
What's your relationship to the property?
Everybody, my name is Julio Martinez. I'm the property manager of the location.
So we have two property managers?
No, she's the property manager for the unit and the property manager for the condo.
Okay. So who is Claudio Balutiones and Maria Florencia Loza?
They're the owners and I represent them.
And you represent them because you're the designated property manager for the building?
For the unit, only the unit.
For the unit in question, which is
Yes.
what, a condo?
Yes.
This is a homeowners association?
Yes.
All right, and Mr. Martinez is the manager for the entire condo?
Yes.
Okay, so having reviewed the file, I saw that there was some emergency work done in the living room. Apparently, the plumbers dug up the entire floor. I saw pictures of it in the file. Do you understand that you need a permit for that, Ms. Cabrera?
We did not do any work. It was an emergency work done by the association. That's why Mr. Martinez is there. They did not entirely, it was just a section, and they did not entirely pick up the whole floor. I think it was like 2 tiles, but we did not do any work. I did let the inspectors know we didn't do anything there. It was an emergency for the condo.
Okay. I understand emergencies, okay? And I want to know whether or not, and Mr. Martinez, was the association responsible for the work that was being done for the plumbing system?
Yes.
Yes.
Okay. And you did that, why? Because there was a leak?
Now, the problem, my magistrate, was that I was called that there was an incident happening into the particular unit. And then we attended to it. We are calling a plumber for the security because water was coming out of the floor. And in the corner, like he said before, is 1 or 2 tiles. And then we had to just open it there and cut the pipe, a 3-inch, 3/4 pipe, and just replace it because the PVC pipe, it was cut for some place, cut open for I think for the age. And the water was coming into it. It was not a major repair. It was not a major doing into that. So we had to do the water was coming to the tile up to the floor and the corner between the kitchen and the living room. And then we just had to dig it in, cut the pipe, put it on a unit, and just seal it back in. And that was the emergency that we had it in. The reason that the city was involved with, because the tenant who was living in the property told there was something major, and she called the city by thinking the city was responsible for it. But then we attended immediately, and as soon as we get a notification from the city, we went and meet the city and explain what happened. So you see that part over there, that's what the plumbing. The reason that I had not after the math permit getting is because that person was in the process to move to Tampa, and then he sealed everything else, and he moved to Tampa and had not been able to get any plumbing to certify that to get a permit for after the math. And that's the reason the permit had not. I spoke to the inspector, I spoke to the directors of the code enforcement about the same situation. Also, we went to the building at the very same day to explain the situation. And the guy told me, that he will go get the permit, but then he moved to Tampa, and I haven't been able to bring him back or to get the permit done. And no one want to be responsible for that little thing to go and get a permit for because it's sealed now, and they cannot witness to that. So I have been getting a hard time to get somebody to go and get me a permit for something that already been covered, and unless they open it back again and they redo everything, that's the person, the closer by one that I could get a permit after the math. So that's the reason that we have not complied with that yet, because I cannot have anybody able to go and get a permit after the math.
Okay, let me hear from the officer. A lot of what you said, sir, was garbled. Maybe you can find another way of dialing in. I probably heard about half of what you said. The other half I couldn't understand because the transmission was not clear. So let me see if you can log in some other way so I can hear you better. But in the meantime, I'm going to ask the inspector to shed some light on what the violation is. Now, we all know that emergency repairs can be done without a building permit. The issue here is having the work done, you still need to come back. First of all, I think you have to notify the building official right away that you're doing emergency work. I think that's what the code says. But then you have to come, after the work is done, then you need to come back and get the permits. Mr. Inspector, tell me what are we, what happened here?
Good morning, Inspector George from the City of North Miami Neighborhood Service Department. That day, the violation was opened on December 8th, 2023. I had received a complaint from the tenant at the time. I went by, I saw that the plumbers were doing the work. I took pictures. So the violation was opened December 8th. The reinspection was for December 13th. There was no, to this day, final reinspection was October 21st. They haven't had no permit on file. They were requested to do a after the fact permit.
Okay, so if they can't get the same guy that did the work to certify it as necessary, and now they need to get someone else, how much time do you think that's going to take?
I'm entirely not sure. That would be dependent on the property manager of the condominium. He mentioned that the plumber that originally did the work moved to Tampa, so he says that he's looking for someone else to do to apply for the permit. So I don't know how to answer that.
All right, let me ask Mr. Martinez. I understand the challenges of getting this done.
Yes, sir.
How much time do you need to find someone to do the plans and submit for the permit and get the permit? How much time do you need?
I don't know if you can hear me now better. You hear me better now?
Go ahead, keep speaking.
Okay. I will let's say that 60 days will be good enough, just to try to get somebody out there.
Okay, I'll give you 60 days. All right, and so within 60 days, you need to get somebody. If you have to dig up and reseal it later, you need to do whatever the city building official thinks is necessary. Is the building official on this call, or I see building official Pressy? Any comments from the building department?
Not at this moment.
Okay, all right. I'm gonna grant the request for 60 days to get the permit finalized. Ms. Cabrera, is there anything else you want to say?
No.
Okay, do you still have a living room, or is it still?
No, yeah, everything is closed. Everything is good.
Okay. Somebody is going to have to go out there and make sure that the work was done properly, recertify it, comply with whatever the building official deems necessary. A permit will be issued, and if the first contractor is not available, you need to find somebody else. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the violation still exists, proper notice has been given, I find in favor of the city, enter an adjudication, and set a compliance date of 60 days through January 6, 2025. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
Thank you, Magistrate.
Okay, you have until January 6th, 60 days. After that, you're going to have to start paying penalties, and that's on the association. It's not going to be on the property. It's not going to be on the tenant.
And thank you.
Okay, all right. Next case.
Thank you.
All right, Magistrate. Next case we have on file is item number 18, Ultimo Garcia, case number CEBPR 2023-00896. This case is, the officer in this case is Gennaro Murillo. I have the attendee Karen De Leon. If you can please accept the invitation and enable audio and video and raise your right hand. Karen De Leon, if you can please raise your right hand. Enable audio, video, and then raise right hand.
Karen, are you there?
For clarification, Ms. De Leon is the HOA president. I believe she's just here as a witness, just to see what's going on with the hearing itself. I don't believe she's going to be testifying. Unless, Ms. De Leon, will you be testifying?
I was here as the HOA president and just to put a request in on it. That was it.
Okay.
We're talking about case number 18?
18.
Eutimio Garcia and Henry Munoz.
Your Honor, for this case, I'm sorry, I gave an extension to the property owner. So he's working with zoning and building department. They requested that they need to put, he needs to remove the pavers and put back the grasses inside of the 60-40 rule. So he's working on that. So I granted him an extension because he was out of the state on vacation and we didn't have no communication, so he's working on that, and I granted the extension since he willing to put everything back as it was.
Okay, I don't recall reviewing the file, and I don't recall that it was a condominium association, an HOA. The HOA president is here.
Yeah, that's me. Yeah, we're not a mandatory. It's in Keystone Point. We work with code, though, on issues like flooding and the like. So we really appreciate the 60-40 because we're having so many problems with flooding.
Okay, this is not a property that you're associated with, correct?
Just a representative from the neighborhood.
I think
this is a single family.
I think you were present when we talked about the ducks.
Oh, charters. Yeah.
Charters. I remember you're seeing you. I just don't remember the specific issue that brought us together. But the request for an extension is do you, Mr. Inspector, do you have a time frame or unlimited extension, or what is your wish?
Yeah, so we're moving for the. I'm willing to give him like a month or 2 months, all depending on the house's progression. But yeah, so he's willing to put everything back. And
okay, if after 30 days he's not complying,
he's coming back to the magistrate.
Then I want to hear it at my next meeting if there's no there's still no compliance. Okay,
yeah, that will happen.
All right, thank you. Next case.
Magistrate, that's all for the attendees. So we'll go from the beginning with item number 1.
Okay, there's nobody else present? Then
there's no one else present. I don't know if you want to take a quick break since there's no one else present, and then we can do this.
We've been at this now for what, a couple hours almost.
Yes.
Anyway, let's take a 10-minute recess. Let's dismiss the interpreters, and then we're gonna move very quickly.
Interpreters, you may leave. Thank you so much for your assistance.
Then we're gonna go through the other cases very quickly. Hopefully, we'll finish by 1 o'clock. Okay, let's aim for that. Okay, all right. So let's take a 10-minute recess. We'll reconvene at exactly noon.
Okay.
Thank you.
Thank you for using our Spanish services. Have a great day.
You too. Yes. The girl? Yeah.
All right, let's get moving. Okay, everybody here?
Yes, sir.
All right.
Yes, they're logging in.
All right, well, we're going to start with number one.
Yes, item number 1.
12040 North Miami Avenue.
Yes, so item number 12040 North Miami Avenue, LLC. Case number is CEBPR 2023-00937. The officer on this case is Shanna Sanders.
Nobody present on behalf of the owner?
No.
All right, officer, can you present the case on that property?
We can't hear you.
I'm sorry. Can you hear me now?
Yes.
Shanna Sanders, Neighborhood Service Inspector. This is a new case that was originally opened and cited on November 27, 2023, whereas I received a call actually from the neighbor regarding a different violation. Long story short, when I visited the property, I saw what appeared to be, some construction going on. I heard some noise from the inside, sound like hammering and things of that nature. I proceeded with leaving a courtesy notice, no response. I left a notice of violation a week later. I have not received any contact or had any conversations with the property owner and or listing agents from the property aside from last week after receiving the notice to appear for this violation. They did reach out to me stating that they had applied for the permit. They were asking for an extension. However, I explained to them, since this was a case that has been open for 11 months short of a year, I was unwilling to give an extension. I thought and was hoping that they would be present at the hearing, because they said that they would be, but as of my last reinspection and my last conversation with them, they have submitted an application for the work to be done. However, no permit has been obtained at this time. So to possibly speed the process up a little bit, I would like to go ahead and possibly have this case adjudicated to get the ball rolling. I am showing proper service was given. I posted the property with a notice to appear on October 1st, 2024. I last re-inspected the property on October 22nd, whereas I do again confirm a building application has been submitted to the city but has not been obtained.
Can you show me a picture again so I can visualize it?
This is the pictures that she's showing is really from just the outside. When I knocked on the door, I did not they did not answer, so I couldn't get any pictures from the inside. But per my verbal conversation with the property owner and the contractor last week when they asked for an extension, they did confirm that they were doing an entire renovation inside and was doing an addition in the rear of the property. But I don't have any photos for the inside.
They went ahead and filed something.
I am showing, yes, I'm showing that they submitted an application to the, I apologize, I keep forgetting their name, the formerly building department. They do have an application on file for it to be processed.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs on the evidence presented depicting that the cited violation still exists, proper notice has been given, I find in favor of the city. Enter an adjudication and set a compliance date of 60 days, January 6, 25. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
You're muted.
Magistrate, really
Yes.
quick, I do have a Jeff Michael who just registered. So I will allow him in. He is item number 21.
Okay.
Let me hold on. Jeff Michael, if you can please accept the invitation and enable your audio and video. And then raise your right hand for me, please, Jeff. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
All right. Item number 21, Jeff Michael and W. Sheila. Case number CEBPR 2024-00066. The officer on this case is Shanna Sanders.
Mr. Michael, you and your wife Sheila own the property at 2700 Northeast 135th Street?
I own the property. We're divorced. She's still where she's me.
Okay, you're coming in garbled, and I'm having trouble. I heard what you said, but are you talking to an iPhone or a computer or what?
I'm on my phone. I just had a call come in. Maybe that was what made it garbled.
Yeah, well, right now.
Can you hear me better now?
Yes. I can hear you, but you're frozen. All right. Anyway, you understand that you were cited for doing some plumbing, electrical, and mechanical work at the property without a permit. Is that correct?
Yes, sir.
All right. How much time do you need to comply with the city's request that you obtain after the fact permits?
I'll do it as quickly as possible. I'm not sure how much time. Hopefully, I'll be able to resolve it in 30 days. I don't think it should be anything I hope I should be able to resolve it quickly.
Okay. What kind of work did you do?
I changed my kitchen. I put in new tile, and I changed my bathrooms.
Okay. So I'll give you 60 days. How's that?
That's fair, sir.
Okay. Officer, do you have any objection to a 60-day extension?
Absolutely not.
I'm going to adjudicate and give them 60 days, okay?
That's great.
Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented, depicting that the cited violation exists and the proper notice has been given, I find in favor of the city. Enter adjudication and set a compliance date of 60 days or January 6, 2025. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated. Sir, thank you very much for attending. You do not owe anything. There's no fine imposed, but after 60 days, if there's still a violation, then the fines will start accruing.
I'll take care of it, sir.
Okay, and if for some unknown, unanticipated reason you run into a problem with the city or the county or Durham or whoever, and you need a little bit more time, you can come back and ask for more time. But right now, we hope that everything is worked out by January 6th of 2025.
Very good.
Thank you. Have a great day.
Thank you. You too.
Next.
All right, Magistrate. Item number 2 is 13240 Northwest 10th Avenue, LLC. Case number is CEOSV 2023-00097. The officer on this case is Jonathan Lemestre.
Mr. Lemestre, I've seen the photographs. You might want to put them up again to refresh my recollection. There's that truck there. Has it been sitting there for a while, or is it used for business? What is your understanding?
So I'm not sure if the box truck has been used for business, but the box truck has been parked and stored at the property. So back on September 16th, 2023, as I was proactively looking for violations, I observed the box truck at the property at 13240 Northwest 10th Avenue. I opened a notice of violation. I mailed the property owner the violation as well. And as of the final reinspection date on October 19th, 2024, the property has failed to remove the box truck from the property. But with that said, I did receive an email from the property owner. The property owner informed me that the box truck belongs to the tenant that resides at the location, and that he already spoke to the tenant and that he had the box truck removed. So after October 19th, I went back to the property several times to inspect, and the box truck is no longer there. But I wanted to bring this case to the magistrate for the fact that if this was to happen again, we would have something on file, an adjudication stating that the box truck was at the property, and we could continue with the fines are found guilty, and if they were to do it again, that we could they could get fined for it.
Well, let me think about it. There was clearly a violation.
Correct.
That violation has been remedied, has been abated, complied with.
Correct, but
I would ask perhaps the city attorney if I can set a one-time fine for the violation that occurred during the period of time that the truck was parked there illegally. I prefer to do that than what you're telling me is the alternative, is to adjudicate. I can't adjudicate something that is no longer a violation. What are my options if the assistant city attorney is still in the meeting? What is the recommendation of the city attorney?
Assistant City Attorney Paul Marie Bob, you are correct. I don't believe we can adjudicate if the violation has been cured. I would lean on the side of the special magistrate and support any decision that you make in terms of having a one-time fine for their issue, because the violation did occur. However, it's been remedied, like you said.
Right. Is there a code provision that assigns a particular fine for this type of violation?
I would have to do some research on that and get back to you, so we can table this item and bring it back if you'd like.
Well, I'll tell you what I'm going to do. I'm going to levy a fine of $500 for the violation. The code probably gives a range. I certainly have the authority to issue fines of $500 for violations under the state statute. I'm going to just go with that, and if the property owner wishes to have me reconsider that, I will reconsider it.
Okay.
If they wish to file an appeal, they can file an appeal, but they did in fact violate the code, and there should be some consequences for that. So I am assessing a $500 one-time fine, and I will assure you that the fine will be significantly more severe if the violation continues. If they bring the truck back, it'll be a higher fine. So let's just leave it at that. Madam Clerk, when you do the order, just show it as a one-time fine of $500 for the time that truck was there in violation of code section, which is in the file 29-5-1406 parentheses D, like in David. That's the violation, and that's the fine.
Okay.
Okay.
All right, moving on to item number 3, 1500 Northeast 137 LLC. Case number is CEBUS 2023-00005. The officer on this case is Shanna Sanders.
Ms. Sanders, I reviewed the file. I saw the picture. I think that if you uncover that, it will say something like Miami minibus. Is that correct?
I believe so. Yes, in the rear, in the back of the bus. Yes. Oh, in the front too. I see. Yep, in the front. Mm-hmm.
Yeah. So what about that other vehicle? Is that a neighbor or?
No, that's them. They have another case that I apologize. I didn't get it on the docket. But they already have another case pending for that box truck that hopefully will be coming before the December, if not maybe February magistrate.
Okay. All right. So today I'm only ruling on the bus.
That's correct. Yes.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days, December 4th, 2024. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated. Next case.
All right, item number 4, 1995 Northeast 124th LLC. Case number is CEBPR 2023-00916. The officer on this case is Gennaro Murillo.
Mr. Murillo, Officer Murillo.
Yes,
Seem
Your
like
Honor.
they seem like they almost redid their house from the pictures that I saw.
1995 Northeast 124th.
Item number 4, Murillo.
1995 Northeast 124th Street.
1 second, I'm sorry. Yes, sir.
Team, let's make sure that we're paying attention as to not have any delays that are unnecessary. Thank you.
I think I throw away my notes by mistake. Give me a second. One moment. This. Okay. This is on 124th Street?
Yes.
Yes.
1995 Northeast 124th Street.
Okay, Your Honor. I'm ready. So this case was opened on September 23rd of 2023 to the property address 1995 Northeast 124th Street. This is for after the fact building permit for the ongoing work that was being done at the driveway. I also put a stop work order on that day. The notice to appeal was posted on October 1st. The notice of appeal was mailed on October 2nd, and I had a final inspection on October 21st, and there has been no permit. Yeah.
It looks a lot more than just a driveway, though.
Yes, no, for the other things, they already obtained a permit, so this is the only one that they haven't obtained a permit.
So for the rest of the house, they
have multiple cases that I opened, so
it looked like they built a new house. So you're telling me that we're just doing the driveway now?
yes, Your Honor.
Okay, all right. And how long do you think it'll take them?
I'm not pretty sure. Let me see what they have here.
Does that include the swale area?
It should, yeah, because they got to do the approach, so yeah, they will have to include the swale area as well.
I'm gonna give them 60 days. If they need more, they should come in and ask for it. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation for the driveway entrance area still exists. Proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 60 days. That is January 6, 2025. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
All right. Item number 5. Benito Files, AIM, and W. Leon. Case number is CEOSV 2023-00089. The officer on this case is Jonathan Lemestre.
Officer Lemestre, briefly point out what the violations are. I've already reviewed the file. It's a violation of the zoning code 25-5-1406D. I know that there's a school bus involved and a commercial vehicle. It has something sign saying farm labor. I hope it's not being used for that, but that's what the sign says. If you could put that up so that everybody can see it.
Yes, sir. So back on March 25th, 2023, as I was patrolling the area, I observed a school bus parked and stored on the property. I posted a notice of violation. There's the school bus, and that's the title.
What does it say on top?
It says farm labor.
Okay.
So I observed the school bus and I opened a notice of violation to have the school bus removed from the property. I mailed the notice of violation, and as the final reinspection date, the school bus remained on the property. They have tried to conceal it. As you can see from this photo, it's a fence. You could see it, and city clerk, if you could show them the other pictures where the fence is covering it. So they attempted to cover it, and it looks like they even attempted to paint the truck black, camouflage it. I was in shock when I came back to reinspect, but they attempted to hide the school bus, but regardless, the school bus still remains on the property.
Well, congratulations to you for uncovering the hidden school bus. They have not spoken with you?
Not this year. When I opened up the violation back in March 2023, I did speak to the owners. I explained to them that school buses, commercial vehicles are not permitted to be stored in a residential neighborhood. I made that loud and clear to them, and but they still haven't complied.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days through December 4th, 2024. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
All right. Item number 7, Catherine Newat, NW Aiz Family Ltd. Case number CELDR 2023-00041. The officer on this case is Shanna Sanders.
Ms. Sanders?
Shanna Sanders, a neighborhood service inspector. This case was originally opened on June 21st, 2023, when after receiving numerous phone calls, numerous emails regarding 3 tanks that were placed out there. Several complainants around the area were complaining that it was hurricane season. These items were out there. They seemed to be filled with oil from the conversations that was had with me in the emails that were sent. I mailed the notice to the property owner, hoping she would, they would contact me regarding the matter. I have not had any contact with anybody from this property whatsoever. So I moved ahead with failing it and requesting that it be presented before the special magistrate. I am showing proper service was given. I posted the property with a notice to appear on October 1st, 2024. I re-inspected the property on October 21st of this year. Again, noting that the barrels were still there.
You know what's inside those containers?
I don't. I don't know personally. I can only go by the conversations and the emails that was brought to me during the original complaint, and said that there was oil in them. But again, I did not and cannot confirm that myself.
Is there any way to gain access to it and physically remove them and take them away?
Well, as you could probably see in my latest picture from my re-inspections, it's a vacant lot that's on the corner of 135th and 2nd Court. As you see, the gate is has been damaged and is clearly open. I don't know if and maybe our director could chime in. If so, maybe I don't know. Maybe our clean team or maybe the manager can say I don't know if there's something that the clean team or the dream team would be able to remove. But clearly that gate is open and exposed for entry.
Yeah, I just worry that there may be some oil in there and could create a problem. But I can only do what I can do. The city knows what needs to be done in the event that you guys decide that you want to remove it yourself and lien the property owner for the cost of that. But what I will do is I will enter an order. We're talking about case number 7, right?
Correct.
Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days, December 4th, 2024. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated. If it turns out that there's something explosive or dangerous or whatever the city deems to be a public safety hazard, of course you have remedies that you can use to remove it.
All right. Item number 8, Darnell L. Monestein, case number CEBPR 2024-00032. The officer on this case is Brentley Daniel.
Okay, let's hear the case.
Yes, Your Honor. Good afternoon. Upon my inspection, I noticed that this was a new wooden gate that was installed. And as I checked the property, I noticed that there was no permit for the wooden gate that was installed. So I went ahead and opened a violation back on February 26, 2024. And as of this point, there has not been a permit that's been issued. I see that the property owner did apply for a permit back on May 28th of 2024, but as of today, it's still showing that it's pending at this time.
Have you spoken with the property owner?
No, sir.
Okay. Make sure that the property owner gets a copy of my order as quickly as possible. Having that order may expedite things. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 60 days through January 6, 2025. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
Thank you, Your Honor.
Mm-hmm. Next.
Case is item number 13. Emra Motelis, case number CEFAW 2023-00129. The officer on this case is Jonathan Lemestre.
Officer Lemestre,
item number 13.
I've looked at the file. I know what it's about. I just want you to put enough facts on the record so that we can move forward.
Yes, sir. Again, Neighborhood Service Inspector Jonathan Lemestre, and this case is being heard for the first time. On August 19th, 2023, I observed the fence damaged at 385 Northwest 132nd Street. Magori, if you could show the pictures of the fence. Yes, correct, and keep going. I observed the fence was damaged at the property. I opened a notice of violation, mailed the notice of violation as well, and as of the final reinspection date, the property owners failed to obtain a permit to repair the damaged fence. The property owner.
Can you hold that? Can you hold those last two pictures for a moment? I want to ask you a question about that.
Yes, sir.
Is that how it looks today?
No, they lifted it up. This was back in 2023, August. Well, this is September 2nd, 2023. This is what it looks like now. This was my final reinspection date, October 19th, 2024. There's another picture where it's being held up by, I don't even know what that is. It looks like an underwear. All right. That's what it looks like. I don't know what that is, but it's being held up by that.
Could have been worse.
It could have been a lot worse.
Yeah.
So I decided to bring it to your attention and bring it to the magistrate.
Okay. Let's. I've seen the file. Did you say whether or not they applied for a permit?
They have not applied for a permit. There is nothing in our system for it.
All right. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 60 days, January 6, 2024. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
All right. Next item we're going to call is item number 14 through item number 17. So item number 14 is Empire Legacy Management Corp., case number CEBPR 2023-00927.
I'd like you to read, since there's nobody here, I'd like you to read all four of them.
Yes. Item number 15, Empire Legacy Management Corp., case number CEBPR 2023-00928. Item number 16, Empire Legacy Management Corp., case number is CEBPR 2023-00929. And item number 17, Empire Legacy Management Corp., case number CEJNK 2023-00055. The officer on this case is Gennaro Murillo.
Mr. Murillo, just show me the photographs to refresh my recollection.
All right.
And point out the first one deals with poor concrete. The second one is a plumbing issue. The third one is a window, and the last one, the 17, is the construction debris.
Yes, Your Honor.
Magistrate, each case has the same photos depicting the same exact thing,
Yes,
so we can look at it on the case.
Yeah, I know that.
Okay. Go ahead, Gennaro.
Yes, Your Honor. So can I read all of them at once, Your Honor?
Yeah, we're gonna do all four of them. Just point out where the violations are.
Okay. So for item 14, for the property address 125 Northwest 126th Street, a case was open on November 11 of 2023. This case was open for the ongoing work of the property, including a fill concrete on the side of the property. You can see the concrete on the side.
Yes.
Also on item 15, same property address. The case was open November 11, same date. This was for a plumbing work that was done on the property without a permit. They were asked to apply for it after the fact. For item 16, this case was open for the new window that was installed at the back of the property without a permit. And from item 17 is for the construction debris that was located on the front and back of the property.
Have you made contact with the owner?
No, Your Honor, never.
Okay.
For all cases, the notice to appear was posted on October 1st. It was mailed on October 21st. And as at my final inspection of October 21st, there has been no compliance.
All right, just so that the record is clear, the first three violations have to do with building permits, section 532 of the code. The final violation, number 17, is under section 10-9. So my orders will be the same on each one, based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented, depicting that the cited violations still exist. Proper notice has been given. I find in favor of the city. Enter an adjudication and set a compliance date of January 6, 2025. That's 60 days. In the event of non-compliance, there shall be a daily fine as to each violation separately of $350 until the violation is abated. Okay, so we're going to have one order for each case separately, setting forth the same compliance date, the same fine in the event of non-compliance.
Thank you.
Okay.
Next item we're going to call is item number 19. Hans Jean Baptiste, case number CEPAC 2023-00014. The officer on this case is Jonathan Lemestre.
Officer Lemestre.
Yes, Magistrate Smith. On October 6, 2023, I opened a notice of violation at 13785 Northwest 7th Avenue. This is in regard to the property owner painting the commercial property without a permit on file. As you can see from the photos from Google Maps, the property was yellow, but they painted the property without obtaining a permit first from the North Miami Building Department. As of the final reinspection date, the property has failed to obtain an after-the-fact permit to paint the property. The applicant did not even apply for a permit, or the subject didn't apply for the permit. I did notify the business owner, because the business is now a hookah lounge. I informed the business owner that, hey, you need to visit the building department to obtain a permit. He told me that he will. He never did. And that's where we are, sir.
Okay. Does the city distinguish between single-family residential properties and commercial properties as far as violations for lack of painting permit?
Only commercial, sir.
So this is the code section that you applied is applicable to commercial properties that do require a permit for painting, but if a single-family homeowner wanted to paint it, as long as it meets one of the colors that is approved by the city, you can go ahead and do it without a permit.
Correct.
Okay. Is this an allowable permit? Could they even get a permit for this color?
I believe they could.
Okay, so they need to just
apply.
Basically apply and get the permit and be done with it, right?
Correct.
All right. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days. December 4th, 2024. The event of non-compliance, there shall be a daily fine of $350 until the violation is abated. Are we done?
Almost, I think. Hold on, let me double check. No, we're not done. All right, the next case we're going to call is item number 29 through 33.
Okay, then.
I'll read all of them into the...
Yeah, read them all. It's all one property.
Yeah.
This was all pursuant to an annual housing inspection of the same condo. And so let's read them all, and then we'll deal with them each separately.
All right, item number 29, Northeast Palm Condo Association, Case number MHVIO 2023-01074, previously found guilty by Magistrate Smith with an abatement date of September 16 of 2024. Fine set at $350 plus the $100 cost assessment. Item number 30, Northeast Palm Condo Association, MHVIO 2023-01075, previously found guilty by Magistrate Smith with an abatement date of September 16 of 2024. Fine set at $350 plus the $100 cost assessment. Item number 31, Northeast Palm Condo Association, case number MHVIO 2023-01076, previously found guilty by Magistrate Smith with an abatement date of September 16. Fine set at $350 plus the $100 cost assessment. Item number 32, Northeast Palm Condo Association, MHVIO 2023-01077, previously found guilty by Magistrate Smith with an abatement date of September 16. Fine set at $350 with the $100 cost assessment. And item number 33, Northeast Palm Condo Association, case number MHVIO 2023-01078, previously found guilty by Magistrate Smith with an abatement date of September 16. Fine set at $350 plus the $100 cost assessment. The officer on this case is Brentley Daniel.
Any compliance by the property owner? Any conversations, contacts, any information you want to share? Can't hear you. You're muted.
My apologies, Magistrate Smith. Yes, I have made contact with the owner of the property. Actually, it just changed. The former property manager is no longer there. It's a new manager who's taken over the property, I think about 2 weeks ago. So he advised me that, he's just new on the scene and he's just trying to do his best to make sure they try to come into compliance with all of the violations.
Have you spoken to any member of the condo board?
No, sir. Just a property manager.
Okay. This is one example why the legislature sometimes goes a little crazy, imposing all kinds of requirements on condo boards. You're just sweeping things under the rug and hoping that one day they'll get better is not an answer. While some of these violations may not necessarily be life safety, they are important, and right. It would be significantly. It would be very helpful if there was somebody from the association that had enough sense to comply with their fiduciary duties. To do the right thing. And if you are not willing to do the right thing, let somebody else take care of the condo. I'm going to go ahead and ratify every one of these fines with separate orders as to each violation, but they will all be have the same language based on the testimony of the city's code compliance officer, the photograph and other evidence presented, noting that the property has been out of compliance since September 16th, 2024, as to each one of the violations. I find for the city, ratify the fines accrued to date in the amount of $350 a day plus $100 cost assessment. These fines shall continue to run on a daily basis until there is compliance. And I would encourage the city to specifically send a copy of my order. You want to go ahead and lien the property, file your liens, and advise the president and each member of the board of directors that their properties are about to be liened and they're going to have some trouble selling or buying units while these liens are pending.
Yes, Your Honor.
Okay, I just want to make sure that they understand their obligations to the condo owners and to the city. And if they don't, there are going to be heavy penalties here, which hopefully will not be mitigated, because that's how you send a message that you're serious. So having said that, let's move on to the next series of cases, and hopefully we'll end pretty soon.
Thank you, Your Honor.
Number 34, Oriel Rose Vinto and Nayelis Labrador Perez.
It's a lot easier. Let me pronounce it for you.
Yes.
Nayelis Labrador Perez.
Perez, okay. So that person.
Oriel Rose Bento. I don't know what nationality that is, but
okay. But I'm gonna call the case number. Case number is CEBPR 2023-00906. The officer on this case is Jonathan Lemestre.
Yes, Special Magistrate, Neighborhood Service Inspector Jonathan Lemestre. This case involves a new door, a new windows, and the carport being enclosed without a permit on file. On September 8, 2023, I opened a notice of violation for those 3 issues. I posted the notice of violation. I also mailed the notice of violation as well. As of the final reinspection date, the property has failed to obtain a permit for the carport, windows, and doors. And if you can look at the photos, this is what it looks like now. I think I have a prior picture. But yes. So again, you can look at the windows, look at the door, and you can see the carport that was there. Yes. They converted it. They built a wall without a permit. There it is. Yeah. So you can see from the lining. That's
a before. Is that a before picture?
So this one is, yes, that's from Google Maps. This is what it used to look like.
Okay.
September 8th, 2023. This is what it looked like when I opened the notice of violation. And there is a newer picture from October 19th, I believe.
Yeah, isn't Google amazing that you can find these things out?
Yes, and this is what it looks like now. Beautiful home, but again, no permit on file for it. They did apply. The property applied for the legalization of the carport on January 26, 2024, but they were denied by Building and Zoning. They applied for it, and the permit is now expired. The property also applied for a permit for the windows and doors on January 26 as well, but they were also denied by zoning. So,
is that because there's too much greenery? Or, I mean, what was the denial? What was it?
I could find out.
Was it, that they do too much construction and not enough greenery, or they don't approve? Is that fake grass?
Yeah, it's artificial grass. Give me 1 second, sir. I could find out the reason why they denied it. (851) Northeast 137th Street.
Doesn't matter if you can't tell me, that's fine. I don't need to have that, but clearly they did work and they don't have a permit. So let me rule. And based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 60 days, January 6, 2025. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
The last group of cases we're going to call is item number 35 through item number 38. Item number 35, Prestige Biscayne LLC, case number CEMHS 2023-00672. Item number 36, Prestige Biscayne LLC, case number CEMHS 2023-00673. Item number 37, Prestige Biscayne LLC, case number CEMHS 2023-00676. And item number 38, Prestige Biscayne LLC, case number CEMHS 2023-00677. The officer on these cases, Christopher Colson.
Officer Paulson, I've reviewed the file. I'd like you to identify the conditions, the pictures, the deficiencies. This was originally an annual housing inspection. The first case has to do with missing window screens. The second one, sliding door screens are missing. The third, a business tax receipt. You don't need to show pictures on that. And the certificate of use is also missing. Just show me the first two, and then I'll rule on all four of them.
Good afternoon, Inspector Christopher Colson, City of North Miami. This the first case is, like we say, for the missing window screens. As you see in the pictures, throughout the property, all the window screens are missing, and it's a requirement by the code that you have the window screens. And I've had contact with the property manager. Say they're going to get them, say they're going to put them in, but as you can see, they still have not in as of today. They're not in. The second case has to do with sliding glass doors. Not the glass doors, but the sliding window screen slides. The sliding screen doors for the door. For the door. And they are missing as well throughout the property. I've been in contact with the Prestige people because I've been doing other stuff with them, plus this stuff, and they're still not in. There are still out of compliance. As a final inspection, both violations still remain. And as you say, the other two cases are the BTR and the CU. Those are out of compliance. They don't have it either. I just checked. Apparently,
JP19 Management LLC is what we call in my business a frequent flyer. It seems like they're all over the place. I just noted one possible mistake on case 36. You cited them under 5-30, and I think that it should be 522, 5-22 as number 35 was. I could not find a 530 having to do with screens, but let's make sure. Yeah, is that correct? I think it should be 5-22, not 5.
Yeah, it should have been. They should have been the same, 522.
Yeah, the first two should be the same, 522. Right.
Yes.
Are we okay on that?
We're okay on that. You're correct.
Right. So as to each violation, separate orders, all will provide for the same abatement date and fine based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists. Proper notice has been given. I find in favor of the city. Enter an adjudication and set a compliance date of 30 days, December 4th, 2024. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated. And I think that in addition to, are these condos, apartment rentals, or what?
These are apartment rentals.
Okay, and we serve the LLC, the GP19 Management LLC, or have we served other people?
We've served the registered agent at the time. I've served the LLC. I went to the office because it's right up the street from here. I went to the office and had personal conversations with them about their properties.
Yeah, well, sometimes it helps when you communicate directly to whoever has the proprietary interest, the owner, board member, as opposed to just a registered agent who may screw up and not tell anybody anything. So I always encourage code officers to go beyond what the code says and serve the owners directly, or anybody that has any interest, a board member or whatever. Anyway, that way things can get moving a lot quicker. Anything else pending that we need to hear, or are we done?
Magistrate, that does conclude everything for today. The agenda for today.
It was a pleasure, Director Roman. I look forward to seeing you when I go and sign the orders. Good work for everybody. I can't believe that we haven't met for so long. I just got invited to about 10 meetings next year. Is that true, Madam Clerk? You sent some invites.
I have for next year. No, I have the list. I'll send over to you for you to approve.
To approve what, the meetings?
For the magistrate, the new magistrate hearings. For
Yeah,
next year.
I unless you hear from me, they're approved.
Okay.
Okay, because whether I'm in town or like now, I'm actually out of town. I can always pick up my computer and plug it in and attend whatever meeting at your discretion. Manager Jose Perez, it's always good to see you. You're always on top of things. I like the way you operate. Everybody have a great rest of your day, and we'll see you next time.
Likewise. Thank you so much.
Thank you.